Good evening, everyone. Let's have a response. Good evening, everyone. Good evening. Okay, it's 5:30. It's a Monday. It's getting dark earlier, but let's enjoy being together here in this space this evening. So first of all, I want to welcome all of you to our new home. NYU Wagner just moved into this building, this beautiful new building, a couple of months ago. So welcome, and I hope this will be the first of many events that you'll join us at this location. And I think you're in for a real treat tonight because we're going to hear a really timely and interesting talk. My name is Terry Gerstein. I direct the NYU Wagner Labor Initiative. The Labor Initiative helps government work better for working people by serving as a hub of analysis and research, strategic guidance, idea generation, and dissemination related to the role of government in advancing and protecting workers' rights. The Labor Initiative focuses especially on state and local government, which are always important, but which I think will play an especially critical role over the next several years. We're going to start tonight with a talk by Federal Trade Commission Commissioner Alvaro Bedoya. Then we'll have a bit of conversation, and then a little small reception afterward to keep the conversation going informally and share some time together. So first I'll introduce Commissioner Bedoya. We are so lucky to have him with us today. He's held his current position since May of 2022. Previously, he founded the Center of Privacy and Technology at Georgetown Law School, and he helped establish the U.S. Senate Judiciary Committee Subcommittee on Privacy as its first chief counsel, among many other accomplishments in his career. The talk he is giving today is the fourth in a really fascinating and important series. He's written and spoken about why this classification of workers as independent contractors instead of as employees is a form of unfair competition, about how corporate concentration can lead to fewer and worse job opportunities for workers, why worker organizing and collective bargaining should not be considered a violation of antitrust laws, and how merger review can consider the impact of mergers not just on product prices, but on workers. So let's give him a warm welcome.
Thank you so much, Terry, for having me and your kind introduction. Thank you for the NYU Wagner Labor Initiative for hosting me. I also want to thank my staff, Strad, who's here with me today, Max Miller, Sophia Reese, Brandon Liu, Aaron Reiki, for their help in preparing their remarks. I'd be remiss if I did not recognize your colleague, Sunila Stephen, who is currently a law student today, who helped with, I think, two of these. I should guess. So some disclaimers before I start. They are important ones. First, I speak just for myself. I'm not speaking for any of the commissioners or our staff. Second, I will be discussing news reports and articles and research that involve companies you have heard of. I have not personally researched these allegations, and I'm not alleging these companies broke the law. I cite these reports rather to illustrate broader trends in our economy. So with that out of the way, let's begin. We tell ourselves a lot of stories about technology. Workplace technology is no exception. So neoclassical economists, for example, tell us that in general, workplace technology makes workers more productive. It lets them do more with less. Why else would a business deploy it? In this telling, more productive workers lead to more jobs, which lead to bigger paychecks. The moral of the story, of course, is that if you want shared prosperity, you want technology in the workplace. I look at workplace technology and think of a different story. Let me read it to you. So it's a story about a town out west named Hodge. Now the people of Hodge made honey. And unfortunately, the town bee was lazy. So the town hired one of those Hodgers to work as a bee watcher. His job is to watch, to keep both his eyes on the lazy town bee, a bee that is watched over harder, you see. He watched and he watched, but in spite of his watch, that bee didn't work any harder, not much. So then somebody said, our old bee watching man just isn't bee watching as hard as he can. He ought to be watched by another hodgepodger. The thing that we need is a bee watcher. Well, how did that work? The bee watcher watched the bee watcher. He didn't watch well. So another hodgepodger had to come in as a watcher. And today, all the hodgers who live in Hodge are watching a watching a watcher who's watching that bee. You're not a hodgepodger. You're lucky. So if you're wondering what on earth I'm talking about, bear with me for a moment and consider the experiences of the people who answer your phone calls to customer service. The modern call center worker is also watching. They're videotaped. They aren't just watching. Calls are recorded, their keystrokes are logged, their web browsing is tracked, their chats are saved, screen grabs are taken of their computers. AI chatbots tell them what to say, when to say it in real time. And their voices are analyzed also in real time to ensure they speak at the right pace, the right words, just the right amount of enthusiasm. And it's not like call centers just use one of these surveillance technologies. They don't just go with that one hodger. The average call center uses 5 forms of surveillance on its employees. The companies that sell this technology to call centers say they can quantify empathy to a fraction of a percent. They say their AI chatbots can tell operators what to say, when to say it. The workers who have to work under and with these technologies find them punitive and baffling. There was a chatbot that confidently told a seasoned call operator that his next caller wanted to buy a home repair plan, only for that operator to discover that the enraged caller had a repair plan, his house was flooding, and no one was there to repair it. Another program set off an alarm for, quote, emotional distress, close quote, anytime a customer started laughing. Still, another AI kept on giving a worker low sentiment scores for her calls. She thought she wasn't using the right words with callers. But no one would tell her the words she needed to say. One worker said it was like having a computer standing over your shoulder, arbitrarily deciding whether you get to keep your job or not. Another worker said, well, the stress has made me sick to my stomach, and I am unable to get out of bed on many mornings to do this job. This kind of thing is common. Let me give you one statistic, too, actually. Most call center workers are prescribed medication for a stress or anxiety-related illness. 1 in 4 of them take this medication constantly. So today I want to talk to you about workplace surveillance and automated management. First, I want to argue that certain uses of worker surveillance and algorithmic management may constitute what we at the FTC call unfair trade practices. I think that looking at worker surveillance through this lens can expand the range of law enforcers who can intervene to protect workers. I think it'll also complement our other authorities, which I won't discuss today, but which include our deception authority, our earnings claims rule, as well as our joint authority over the Fair Credit Reporting Act. But this theory of unfairness won't cover everything. And so my second goal today is to call for lawmakers to pass meaningful worker privacy laws to ensure that no one falls through those gaps. So some of you in the room I know are from our state attorneys general's offices and will know the legal test for unfairness. For everyone else, that test is set out in our authorizing statute, in the Federal Trade Commission Act. That defines an unfair trade practice as, quote, an act or practice that causes or is likely to cause substantial injury to consumers, which is not reasonably avoidable by consumers themselves, and is not outweighed by countervailing benefits to consumers or competition. If you think about it, each step in that 3-part test could be said to be kind of a flip side to some assumptions that we often make about technology. So, some people assume that workplace surveillance and automated management will make workers more productive, and it will help them. What if it hurts them? What if it causes them substantial injury? Some claim that this technology will give workers more control over their work and work-life balance. What if it strips them of control? What if it makes it impossible for them to avoid those injuries? Finally, we all tend to assume that technology works. What if it doesn't? What if the advertised benefits of this technology are unvalidated by science? What if they're outweighed by the harm they cause to working people? So let's go through each of those steps of that unfairness test and compare them to workplace surveillance and automated management techniques we see in the market today. Let's not just look at kind of niche startups. Let's look at 3 established industries that employ millions of Americans right now today. Let's talk about warehouse workers. Let's talk about rideshare drivers. And then let's return to the call center. We'll start with substantial injury. In the US, the idea that workplace innovation will help worker and employee alike runs back to one person, Frederick Winslow Taylor, father of Taylors. Taylor was no tribute to the American worker. I can't call myself an admirer. Let's pay attention to how this paragon of workplace productivity talked about productivity. As many of you know, Taylor urged employers to minimize the distance that a product travels on the line, to carefully measure the movements that workers make, to figure out which maneuvers cause them the least strain. The interesting thing is that by doing all this, Taylor said he wanted to lower the amount of effort required of workers while increasing their output. In contrast, Taylor expressly rejected, in no uncertain terms, employers, quote, whose attitude toward their workmen has been that of trying to get the largest amount of work for the smallest amount of wages. He rejected that. And yet, modern workers talk about those kinds of systems all the time. And some of the most frequent allegations about pace of work come from warehouse workers. The journalist Josh DeZiza wrote an essay that profiled a man who worked fulfilling shoppers' orders at a warehouse in Florida. Journalists called him Jake, which is a pseudonym. Now, Jake's job itself, simple. He picked products up from a conveyor belt, hit a button, put the product in its assigned cubby, hit another button. Everything else about the job was hard. Jake was basically twisting and lunging every 10 seconds for the entire day. His pace was automatically tracked and compared to that of his coworkers. The fastest would be put on a digital leaderboard, much like you would expect at some kind of racetrack betting site. Supervisors would walk the warehouse looking at numbers and telling people to go faster when their rate went down. If you slowed down too much, you got fired, allegedly automatically. Well, you're not stopping, Jake said. You are literally not stopping. It's like leaving your house and just running and not stopping for anything for 10 straight hours, just running. Eventually, Jake damaged 2 discs and went on disability and claimed that the company was found to be 100% responsible for that injury. But it wasn't just Jake who said the pace of his job hurt him. In 2021 and again 2022, the Occupational Safety and Health Administration found, quote, a direct connection between his company's employee monitoring and discipline systems and the musculoskeletal injuries and disorders experienced by its workers in 2 of its warehouses outside of them. Some warehouses even have vending machines that don't stock Coke or Pepsi or chips or that kind of thing, but stock painkillers instead. I do not think that we can assume that workplace surveillance and automated management increase productivity. I don't think we can assume they help workers, because in some of the most sophisticated companies in the world, many of those systems seem to simply increase effort. They seem to simply, quote, get the largest amount of work for the smallest possible wages. And they may increase that effort to the point where it substantially injures people. So substantial injury, that was the first component of that unfairness test. The second is that the conduct cannot be reasonably avoidable. For this requirement, let's talk about the experiences of rideshare drivers. Now, the last time I was in New York last month, I sat down with some of these drivers at a roundtable organized up at Fordham Law School by Professor Teachout and the New York taxi workers. Reporters for Bloomberg actually subsequently interviewed many of those drivers for a feature story that ran a few days after that. The first speaker there was a gentleman named Mohammed, and he started to drive for the app around 2016 after there was a collapse of the taxi industry. Like a lot of drivers, he'd been attracted by this idea that the job would be flexible, that he would be in control of his work balance. He told me that he liked that the companies called him a partner. You're a partner for us, he told me. And he was a good partner. Over 9 years, Mr. Mohammed logged over 21,000 rides, maintained 100% acceptance rate, and maintained a 5-star rating. But over the past few months, that control and flexibility had evaporated. Because when those drivers got up in the morning to drive, the app started informing them they could not go. Other times they start the day, get a few fares, and then the moment they stop for breakfast or for the bathroom, they get kicked off. Bloomberg actually tracked Mr. Mohammed for one day, I think it was in August, to see what that was like. So this is how the day went. Gets up at 5, opens the apps, and finds that he's locked out of both of them. He gets ready, gets dressed, does his prayers, gets on the road around 6:30 a.m. And one of the apps said to go to a busier area. So he started to do that. An hour and 7 minutes later, the app unlocked him, and he was able to get a single fare in Brooklyn. 10 minutes later, the app locked him out again without explanation. 7 minutes after that, he was unlocked. Again, no explanation. He took a passenger in Manhattan and then got locked out yet again. This time, the app told him that he wouldn't be unlocked until 5 p.m., but then it unlocked him at 10:49 a.m. That day alone, Mr. Mohammed couldn't get fares for 3 of the 5 hours he was on the road. It's luck, he said. I don't know how it works. He told me he now has to do 12-hour shifts to earn the same amount he used to earn before. He's $2,000 in debt on his credit card, doesn't repair his car, clean his car anywhere near the frequency he used to. And frankly, a lot of the other drivers who showed up that day had a lot worse. Some had credit card debt up to $10,000. Some were tens of thousands of dollars in debt for cars that they'd expressly purchased to drive for these apps. One driver couldn't afford to visit his wife the day she gave birth to their child. Another driver is now so afraid of getting locked out that he will not stop for food or rest or bathroom as long as he is locked out. And sometimes he logs 13-hour days. But this feeling of lack of control isn't limited to New York City rideshare drivers. Last year, Professor Vina Dubal published findings from 8 years of research with rideshare drivers in the Bay Area. And the driver she talked to had no idea how the app set their pay. Some drivers reported being paid different fares for basically the same rides. Other drivers reported that somehow they would make more money per hour when they drove for less time. They talked about the app's, quote, casino mechanics and how riding for the apps was like, quote, gambling, because you never knew what you'd get, but the house always wins, quote. One driver named Carlos told Professor Dubal, not asking for a revolution, I'm asking for fairness. I'm asking to make enough to live, to know how much I'm going to make from one day to the next, to have some predictability. Predictability, of course, is what many gig economy companies promise Americans. We cannot assume that they get it, because in many instances, the automated management systems that power these platforms appear to make it impossible for working people to predict or avoid the injuries that may come with their jobs. I think it's reasonable to ask, if an app isn't treating you right, why don't you go to another one? Well, I think these workers would say it's not one app, it's both. And the taxi industry, which otherwise I would go to, is a shadow of what it used to be directly as a result of ride sharing. I think they'd say there's no avoiding it outside of simply changing jobs. That was reasonable avoidability. It's a second requirement in the unfairness test. The third requirement commanded by Congress is that the alleged injuries suffered not be outweighed by, quote, countervailing benefits to consumers or competition.
we've been talking about a lot of the assumptions that we make about technology, workplace technology. I do think the most basic assumption that a lot of us carry around is that technology works. How does it work? Let's return to the technology that used the customer service centers. This is actually technically called speech emotion recognition, SER technology. And what it does is try to analyze the sentiment of a call. The New York Times recently profiled a call center worker who encountered this technology. Her name was Yolanda Sherrod. And she had a childhood. She grew up in the Mississippi coast in Pascagoula. She lost her mom at age 5. And her family depended on public benefits growing up. And Miss Sherrod's, call center job helped her get a life where she didn't have to depend on manual, low-paid jobs. Fast food and cleaning the casino, that's right there on the Gulf Coast. She loved that job, and she was good at it for, I think it was 2 or 3 years running. She was in the top 3% of the company's call representatives. Then the company started using AI to analyze and evaluate its employees' calls. Now, speech emotion recognition technology tracks the words used by customer service representatives, as well as their tone, their pace, and their volume. So if you want to actually succeed, in theory, if this is possible, in recognizing emotions, it is critically important that the technology, at a minimum, accurately understand exactly what call center workers are saying. Now, as I mentioned, Ms. Sherrod is from Pascagoula, Mississippi, on the Gulf Coast. And actually, I was just down there. I was down in Biloxi, which is just to the west. And if you've been there, you know that folks from that part of the country speak differently than folks in New York or Washington, D.C., in that matter, for that matter. And Ms. Sherrod started noticing that the transcripts for her calls were full of errors. The software had trouble with her accent. She also learned that soon she would not be able to correct those call transcripts. And she was acutely worried that those kinds of errors would eventually cost her her job. And there are many more anecdotes like this that do end in someone losing their job. The Wall Street Journal interviewed a call center agent with a Filipino accent. She'd been recognized as a top performer again 4 years in a row. And then automated emotion recognition came in. Her scores were too low, even though her boss continued to tell her that she was doing a good job. And eventually she left that company as well. But it's more than anecdotes, because peer-reviewed scientific literature suggests that this technology may perform differently depending on a speaker's gender, age, disability, and regional origin. Speech emotion recognition, it's critical to observe, is not some niche technology of the future. Half of all call center workers report that the emotion in their voices is monitored. And for 1 in 4, it is monitored constantly. This kind of technology may be marketed as sophisticated. It may be deployed by some of the wealthiest, most tech-savvy companies in existence on thousands upon thousands of their employees. But we cannot assume the benefits of these technologies. We can't assume they work as advertised. We cannot assume they work, period. Because some of this technology will indeed help workers, but a lot of it is a one-way ticket to arbitrage. It is more than plausible, in my view, that some of these technologies may substantially injure people in a way they reasonably cannot avoid, such that the harms of these technologies are not outweighed by some countervailing benefits. In other words, I think it's more plausible that they may constitute unfair trade practices. As many of you here may know, all 50 states have not exactly the same, but similar prohibitions against unfair trade practices on their law books. And I think that looking at workplace surveillance and automated management through this lens may therefore expand the number of law enforcers who can protect working people from the harms that flow from this technology. But look, you have to recognize these cases are going to take time. We also need to recognize that when these cases come up, companies will cite that last prong of countervailing benefits and point to the financial benefits of those practices. And you better believe they've quantified them. That process will take time also. So on a final note, candidly, I'm not sure we have a lot of time. 2 in 3 workers in all industries across the country, it's a recent survey came out, are subject to some kind of electronic monitoring on the job. And 2 in 5 are subject to some kind of automated scheduling or task management. And I think that if we're going to address the harms raised by workplace surveillance and automated management, we need to pair use of the unfairness authority and use of all the other authorities in play, FCRA, OSHA, NLRB rules, NLRA, along with the passage of meaningful workplace privacy laws. And I call on Congress and the states to do that today. Now, to underscore the need for those kinds of laws, workplace privacy laws, let me share one last story about something that I do think is a technology of the future. For starters, how many of you have heard of the actor and martial artist Jet Li? All right. You know what this is? No? Okay. So around 20 years ago, Jet Li was approached about starring in one of the sequels to The Matrix. This was a dream job. I don't know if you're familiar with The Matrix, but this was sure to be a hit, this sequel. But there was one catch. If Mr. Li took the job, he would have to agree to have all of his moves scanned and saved into a digital library. Mr. Li said, no. He said, I've been training my whole life, and we martial artists can only grow older. Yet they could own my moves as intellectual property forever. Now, I find this again a little jarring, but what jumps out at me is actually the opposite, is that he was told that his job would involve body scanning. He was told who would scan it. He was told who would own the data, and he was given the choice to accept or decline. A few months ago, in August, I heard an NPR interview with a modern motion actor we probably haven't heard of. His name is Jaziri Booker. And he is one of the motion actors, the movement actors, used to create the Spider-Man character for the video game adaptation of the Marvel movie franchise. Now, his job is to spend hours upon hours on set wearing a full bodysuit covered in these reflective patches, these sensors, performing parkour, breakdancing, capoeira, jiu-jitsu, everything. And even though he was doing precisely what Jet Li was asked to, Mr. Booker had no idea what was happening to his data. He was on strike at the time. Actually, he told NPR that, quote, our ask is not that they don't use AI altogether. We're saying at the very least, please inform us and allow us to consent to the performances that you're generating with our AI adults. It's not just motion actors. If you read enough about call center workers, you'll find references to how call center workers themselves have their calls logged. And even within Hollywood, it isn't the folks who are in front of the camera, background actors. These are the stories I frankly found most challenging. Around the time of the actor strike, you would find these stories about background actors, extras, who were tapped on the shoulder once they were already on set and told to submit to full body scans, often with no notice, no contracts or paperwork, no extra pay, and with no information about how that data would be used in the future. So, you hear about automation all the time. And it's true, technology is replacing workers through automation. As we discussed today, it already regulates them through workplace surveillance and automated management. In the future, it will replicate it. And the question of whether or not workers should be scanned and replicated should not come down, in my view, to a three-part legal test. Workers need strong, bright line protections against this conduct, and they need them now. Now, right now, there's two roads to get those kinds of protections. The first is organized and collective bargaining. The Screen Actors Guild won, frankly, the strongest protection I'm aware of to ensure that their digital replicas would not be made of actors without their knowing about it, without their agreeing with it, and without their being paid for it. The Communications Workers of America have made sure that emotion analysis software here in the US can be used to punish or discipline workers. And if you look abroad, the gains they've made are even greater. That's the first path, bargaining. The second path is through passage of a workplace privacy. Put it this way, if your bank or your hospital or your email provider goes out and sells your records to the highest bidder, law enforcement does not need to listen to arguments about how much money those companies made when they sold their data. All they need to show is that those companies broke privacy laws. This legislation could and should be developed arm in arm with representatives from organized labor to ensure that it is responsive to what workers are actually experiencing. And it should include protections not just on the collection of data or the sharing of data, but on the use of data, particularly within algorithmic management. You know, some people may think it's absurd to talk about Hodgepodge, to talk about Dr. Seuss, and talk like this. I think it's absurd that almost no privacy laws apply to the workplace. How can it be that when I sit at home and watch television, turn on cable, enter my credit card information, or watch a show online, all that information can be protected by privacy laws? But when I work, when I show up at work, seemingly anything goes. How can it be that people show up at work today, right now, no idea who will scan them and measure them, analyze them, and with no control over those processes and no idea of how that data will be used? That is what I think is absurd. I think it's high time to fix. Thank you.
So thank you so much, Commissioner Bedoya, for that wonderful talk. I have so many questions, and we have finite time, which is always the problem. But maybe we'll start out just with a question about what motivated you to write this talk and to focus on these privacy and surveillance issues.
Sure. I think it's two things. And the first is well, first of all, let me say thank you for this. This is great. This is a really exciting place to be. And I'm grateful that all of you came out on a Monday night to come listen. So thank you. So two answers. The first is before I went into privacy, I was the Chief Counsel of Privacy Subcommittee in the Senate. My first actual job was working for the International Labor Organization on their special action program, combat forced labor. And so I had this background, and I always wanted to look into workplace privacy. And in fact, I held a conference on it in Georgetown. But the trigger for this was actually something I didn't put in this talk. It was actually an earlier draft. It was this moment where I stumbled upon the field, not of emotion analysis, but of emotion modification technology. So let me do another re-up of my disclaimer. I'm not accusing this company of breaking the law. But if you Google or YouTube search Thrive Reset video, you will encounter a video that plays the following scenario. You're at a call center. End of the day, hard day, don't feel that great, stressed out, everything's being measured, call after call after call comes in, and someone just cusses you out, and you have a terrible call, you raise your voice, you get angry, and that call ends. Instead of getting the next call, what appears is a video of the Himalayas, a beach, of a wooded path with quotes from Frida Kahlo, Heraclitus, I don't know how to pronounce that, and Cher. Set in a montage. It's little a real person's family photos. This is on YouTube. And that is a well-capitalized company that is selling this technology to major Fortune 500 companies. And that's a real thing. And that was the moment where I said, okay, maybe I should look into this whole workplace surveillance.
Thank you. Well, that raises another one of the questions that I was thinking in relation to your talk, which is a little wonky, but who is the consumer? You talked about
Sure.
the legal test, has 3 prongs and defining, what the harm is, and consumers, is the consumer the worker? Is the consumer that's being harmed the employer?
Right. So I think it's both in many instances. So first of all, if you look at our gig worker policy statement, we're on the record saying that term should be interpreted broadly to include working people. Once more, we brought Section 5 cases under the other prong, deception, for rideshare drivers. I think we recently brought one against Lyft. We brought another one against Amazon Flex drivers. So we're on, we have a legal record, both in policy statements and settlements on this. So I think it's the worker. I also think in many instances it's the business. So if you look at call centers, the software is developed not by the call center typically, it's developed by a vendor that sells the company to the workplace that purchases it. And so I think that both workers and their workplaces in different circumstances can be considered, should be considered.
So at the end of your talk, and sort of implicit in all of it, is a call for legislation to protect workplace privacy. And you don't have to actually like draft something right now on the spot, but can you give us a sense of what those laws might actually look like?
Yeah. So and I didn't put this in the talk because I think the way it works is for the actual people who will be affected by it to work with their legislators to draft it. But sure, if I were asked, this is what I'd say. Let's start with kind of most vanilla, or at least clear, to some of the areas that I think are very needed, but I think will require more thinking. So first of all, I think there should be some bright line rules. First of all, I do not think it can be a condition of employment to surrender your biometrics. I think that just like Europe did in the AI Act, there's a strong policy case for emotion analysis to be banned in the workplace. So bright line rules against collection of biometrics. Already there's a bright line rule against collection of your DNA by your employer under GINA. Why on earth do we not have something like that for biometrics as well? Why can't we have that bright line rule against emotion analysis? Secondly, the Fair Credit Reporting Act actually has a lot of pretty solid rules, not perfect, pretty solid rules though, around using data about people to make decisions about them. And as Director Chopra, the CFPB, has very wisely put out, just put out guidance saying how that applies to workplace surveillance and automated management. CFPB themselves recognize that FICRA governs these third-party CRAs, right? So if an employer themselves develops these files on people and uses them to make decisions, a little harder to make the case that FICRA applies. So why don't we apply these FICRA protections?
FICRA being the
Fair Credit Reporting. Sorry, I speak in acronyms. Lastly, this is another thing that make them talk, but you read labor history, you read these crazy facts about what workers used to protect from their employers. In like 19th century England, craftsmen would just stop working when the boss came into the room. And it was just understood that this is our knowledge. You do not, this is not your knowledge, and we shall not give it to you. There's other history around people being asked to work regular hours. Like nowadays, we'd be like, how could you not work regular? It's chaos, right? No, people say, this is my work. I can work, whatever I want. Why are you telling me I need to work regular hours? Another one was, this is a 20th century example. People being asked to submit to time clocks, and people just being, I'm not a robot. What? You asked me to clock in like on some kind of machine, and I think we should retain some of that skepticism around this assumption that how you do your job is something your employer is entitled to as a default. And I don't know if I can make that case in enforcement action. I genuinely don't know. I haven't thought about it. But I do know that legislators can case it. So some people might say, in the example of the movement actors or some of the extras, does it name, image, likeness apply to that? And sure, if you take someone's name, image, likeness, and you just profit off of it, in certain circumstances it'll apply. From our look at the law, if you average people, name, image, likeness doesn't apply because you're not replicating some specific name, image, or likeness. Separately, movements are often not covered in those kinds of laws. And so I think the last and the real challenge would be trying to have some kinds of rules about when an employer can copy your livelihood, your profession. And I don't know exactly what those rules should be, but I think they should exist.
So backing up a bit for people who don't know, just what is the Federal Trade Commission and what does it do?
Yeah, so the FTC was created in 1914. Louis Brandeis was one of the framers of it. And at first we were fundamentally a competition protection agency. And then in 1938, there started being a lot of cases where people would basically make a lot of money and beat the competition by lying, just saying, oh, my elixir cures cancer, right? So I don't want to buy that. And those started out as unfair competition cases, but then they became unfair and deceptive trade practices cases. So now we have two houses fundamentally. We have a consumer protection side of the house, which does privacy, anti-fraud, that kind of thing, but also dozens and dozens of other laws. So laws protecting against bots, gobbling up tickets online, made in USA rules, that kind of thing. And then we've got our competition side of the house, which gets at mergers and acquisitions, gets at anti-competitive conduct, and that kind of thing. So that's fundamentally what we do. We're a commission of 5 members, 3 from the president's party, 2 from the other party, opposition party. That's who we are.
So I want to talk a little bit about antitrust law, because there's been a real sea change in antitrust law in the past several years, where historically it was really focused on competition in markets for products, but in the last several years there's been a real focus on labor market fairness, labor market competition, on anti-competitive practices that harm worker mobility or that suppress wages. Can you tell us a little bit about this shift and evolution and why you think it's happening, and just share some examples with us?
Absolutely. I would characterize this shift as a return to the original purposes of the law. I know some of you are faculty, some of you are practitioners of different sorts out in the world. Some of you are students. If you're a student, one of the best things you can do if you're trying to understand the law is go back to the legislative history and read the debates in Congress, which are written down for the most part, particularly 20th century and onwards, in great detail. And the fascinating thing is that, if someone woke you up in 2005 and was like, what's antitrust law? You'd be like, oh, it's about prices to consumers, and that's what it's about. It's about preventing anti-competitive mergers and conduct that raises prices. It's about consumer welfare. All right. You go back to the Sherman Act debates of 1890, barely talk about price to consumer. They mostly talk about small farmers, small businessmen getting screwed by the trusts over and over and over again. In fact, fun fact, the original Sherman Act, which was written by John Sherman, mentioned things that tend to, quote, advance price, in other words, raise price on consumers. The actual Sherman Act that passed, A, was not written by John Sherman, and B, makes no mention of price. But what the people did talk about a lot on the floor was 2 things. First of all, making sure that this law wasn't used as a cudgel against organized labor, right? Because it was farmers, businessmen, and labor who were demanding passage of these laws. That was the overriding concern with respect to labor. But you also heard John Sherman go to the floor and say, we need this law because the trusts go out there and, quote, command the price of labor without fear of strikes. For in their field, they allow no competitors. You work on it. And so I think that by returning to make sure we protect labor competition in mergers and in conduct, we're returning to the original purposes. The last thing I'll say, Eric Posner up in Chicago has talked a lot about this. There was this kind of funny consensus among economists as recently as 10 or 15 years ago that labor monopsony, which is the flip side of monopoly. Monopoly is you have a corner of the market on selling something. Monopsony is a corner of the market on buying something. Everyone sort of thought among kind of economists that labor monopsony wasn't really a thing. And now that's kind of done a 180, where most economists would say, oh no, it's very much a thing. And the Department of Treasury quantified it and said, people probably lose on the order of like 1 or 2 paychecks per year for the fact that we don't live in a perfectly competitive market. So I think all of those things, I think Chair Khan has been really strong about returning these original purposes. You look at the original purpose, labor's there, and then separately the shift in economics, I think has been a part of it.
And I know you can't talk about it because these are pending matters, but I'll just mention for people who may not be familiar with it that the FTC proposed a rule that's currently being litigated to ban non-compete provisions in employment contracts, and is also fighting a merger of two ginormous supermarket chains, in large part because of the harmful impact on workers and wages. So so those are just two really great, I know you can't say anything about it, those are two really great examples of the FTC sort of taking a very, very different kind of approach that really centers workers. So let's talk about the elephant in the room. There's a new federal administration that's going to be starting in a couple of months. How are you thinking, first of all, what happens with the FTC? You said that there's 3 members of the president's party. And how are you thinking about your role in this new reality, and what do you predict, if you have any predictions about what will happen with the FTC?
Yeah. So I have no predictions, but I have hopes and I have responsibilities. So what happens is statute, entitles the president to appoint a chair. And so at some point, it will, in the interim, there will be named, so the inauguration will happen, then an acting chair will be named. And then at some point, a new chair, either the acting will be elevated to full chair and someone else will come in to form the new majority. And, or a new chair will be named other than the 2 current Republican commissioners, and they will become the chair. So, look, I don't have any more insight as to the direction this new administration will go on the FTC. I will say there are some very prominent members of the administration, including Vice President Vance, who were very supportive of Chair Khan specifically, but the work of the FTC more broadly. My hope is that that sentiment is carried through the appointments and new leadership. My specific hope is that this new focus on labor, or return to this focus on labor, continues in a new administration. I think a lot of prominent members of the Republican Party, Senator Vance, President-elect Vance, Vice President-elect Vance, Senator Hawley, among others, have been pretty outspoken about the need to do right by labor, and my hope is that extends into a new FTC on labor and antitrust. But at the end of the day, I am one commissioner, and I have responsibilities irrespective of what the new priorities are. And so, I have standard priorities. I need to do my job. I need to enforce the antitrust laws, the consumer protection laws, but I also have responsibilities that I've taken an oath to enforce. And so, if you look at the oath of office that Congress has that makes people like me take, it is broader than our job responsibilities, and it includes defending the Constitution. And so my hope is that if some circumstances require it, that I will do so, but I don't know what form or shape that will take. I just know the oath I took and the job I have.
Thank you. And thank you for taking that oath and for doing that job. It's a good moment also to note that whatever happens at the federal level, as you mentioned, that there are state laws, there are state attorneys general, there's a lot of room for state action and for bold, non-tentative state action in this area. You've given a series of talks. This is one of a number, offering a really insightful and bold new vision for the FTC and for competition and consumer law. Can you share with us a little bit about, like, A, what are the greatest hits of your talks,
Sure.
and B, what made you decide to give this series of talks, and what are you hoping to accomplish by doing so?
Thank you. And thank you for that question. Thank you for your interest in this. I have a couple answers. So first one I've actually already shared, which is I think that the people don't fully appreciate. These are the things I've learned. I think those might be the way to describe. I think we said greatest hits. The first is I think most people do not know just how concerned the people who passed our antitrust laws were about labor and about what was happening and how instrumental they were in passing those laws and shaping them. That's the first thing. The second thing is I think that what actually happened after passage of those laws is frankly one of the ugliest things I've seen happen in the American legal system, which is 1890, 1914, 1932, Congress passes not one, not two, but three separate laws. And each time they go out of their way to say, do not use this against workers. And then immediately afterwards, antitrust enforcers, first DOJ, but eventually FTC, does precisely that. They use antitrust to go after organizing workers under the theory that, oh, just like you can't, collude on price, for your product, you can't collude on price for your wages, and you kind of describe labor organizing in that context. And I think that anyone who describes themselves as an originalist with respect to legislation cannot look at our antitrust laws and not conclude that it was never intended to be used against organized workers. I think that is the second point. The third point, did I take 2 points? I'm not sure, a little tired. But here's the third point. I think that antitrust is full of these anodyne, dry, formalistic terms. Labor monopsony, elimination of double marginalization, which is EDM, which is first I was like, I'm trying to dance music. And if you open up, if you just buy a horn book, which is what we lawyers call the summaries of a course, let's say, for antitrust, you will literally, before you hear about John Sherman, you're going to see charts, you're going to see line graphs about, dead weight loss. Antitrust has become a math. Antitrust has become a technical, formalistic profession. And let me tell you, the folks who passed these laws were not technical and formalistic. They were pissed. They were pissed about what big business, what the trusts of, we called them trusts before, were doing to businesses, farmers, and workers. Number one. And number two, I think that this anodyne pall, this formalistic pall, this idea that, it's complicated, I don't know if you're going to understand, that's been cast over antitrust, has really hidden how companies merging can hurt workers, physically hurt workers, how anti-competitive conduct physically hurts workers, which is why you heard, didn't talk about antitrust today, how workplace surveillance physically hurts workers. And I'll give you one example, and I'll get off my soapbox. So think about the beef trust, okay? So most people think of the beef. What is the beef trust? What the hell is a beef trust? So there used to be lots of meat packing houses in this country, but then they consolidated into 4 that were headquartered in Chicago, okay? It was a monopsony, first and foremost, in the sense that if you were a cattle rancher anywhere near there, you used to have lots of places to process your cattle. And then suddenly you had 4, and there really wasn't 4, there was 1, and that was the beef trust, because they literally met on every Tuesday to set the price at which they would buy cattle, right? So that's bad, right? Bad thing. Price to ranchers went down. Price of beef, pretty important, went up. What happened to the workers? So if you read The Jungle by Upton Sinclair, you are reading what happened to the workers, because the workers also did not have 4 places to go to work. They had 1. Because if you walked off on the job, if you tried to organize a protest, you'd be blacklisted and you couldn't go anywhere else. And so a lot of those workers developed a lot of skills. So there was a story I told, I think in the second to last lecture that you worked on, Cindy, about Annie Lavery and the can labelers. There are these women who became specialists at labeling cans, right? And it was a specific skill to label a can in fast pace, in this assembly line. You were often decorating, you were actually making the can labels, you were putting them on very quickly. And they got so good that because they're working piece rate, they actually got to earn a pretty decent living. But then the beef trust was like, we don't want this. And so they just cut the rate. And so they walked off of the job, and they never got those jobs again. One of them died. The fastest one, literally died of consumption, I think a year later, because she couldn't get work. And then you fast forward to the modern day, look at meat processing plants in the American South. Look at Arkansas. there used to be this thriving small industry of small poultry producers. And I haven't looked at it. I bet you, though, the way they treated chickens is a lot better the way they do now. And so there used to be lots of places to process chickens. Now there's just one. And if you look at the working conditions and you put them side by side with Upton Sinclair, Teddy Roosevelt's commission he sent to the meat packers, you will see the same things. People working in frigid cold temperatures, water dripping on their heads, being paid basically subsistence or subsistence wages. All of those things are products of labor monopsony. So the last point of these talks is to say, this isn't about monopsony, this isn't about EDM, this isn't about any term you have trouble hearing across your eyes when you hear it. It's about regular people getting hurt because these companies are ignoring our antitrust laws and crushing competition.
So I think we're just about at the end of our time, and I'm going to ask what is sort of my go-to final question. And I think it's an especially important question right now, which is, what is something that's giving you hope these days?
So thank you for giving me a heads up here, and we asked you this question. Let me tell you, so I have these conversations with my father-in-law and my wife's family. He and I are the ones that watch politics the closest. And it's not just, something that's happened recently that we talk about. It's everything. It's climate change, it's wars, it's everything. And often at the end of it, I tell them, Dr. Zeta, I can't just focus on everything that's terrible. I got 2 kids, and one is 4, one is 6, and it is literally my job, A, to do anything I can to make things better, and B, to present them with a vision of the world that they are excited about. One of the things, so I started a nonprofit when I was a lot younger, and one of the fun things about starting a nonprofit is that you don't know or a business is you don't know what you can't do, right? And so you'll do this stuff, and by simple fact that you don't know, like, oh, I'm not supposed to build my own file management software. Oh, I'm not supposed to, do this thing that normally requires like 3 full-time employees with like 10 part-time volunteers to do this at night. But you do it. We did it, right? We launched a scholarship. And I look back and I realized that no one had told me I couldn't do that. And as a result, me and the colleagues I got together with started the first status blind college scholarship in the DC region for immigrant students. Because no one really told us we couldn't, right? And we literally built our own file sharing software, did all this stuff that everyone after was like, you did what? And you know how many full-time employees? And all that was a simple fact that we didn't know. And in that same way, I think that it is a parent's job to show their children a world that is intelligent to them, that is hopeful to them, that bears promise for them. Whether or not it does, there's a good and sad poem refers to good bones. Someone remember it? Mm-hmm. What is it? Mm-hmm.
It could be such a
good house and it's good bones. It's really dark, but it's the silver lining to that poem, if there is one, is that it is the parent's job to not show that side of the world to their kids, and that's what I hope for. I hope I can succeed in that. More importantly, is my job. So I don't know if that's as hopeful as you want. Yeah. Thank you.
Well, thank you so much. Let's Terry. Give a
thank you, Shannon.
Has done such a great job. Shannon helps with everything. I want to thank all of you for coming tonight. We have a little reception. Please stay and continue the conversation. And it's really just beautiful to have some time together to be in community.